Mr. Mastagni?
Thank you, Your Honor, and good morning, Justices. May it please the Court, I'm David Mastagni, appearing on behalf of respondents. I would like to defer the last 10 minutes of my allotted time to my colleague, Mr. Talbot, to address issues pertaining to equitable estoppel. I will address why PEPRA's amendments to the SERL impermissibly reduced the definition of includable compensation in the pension formula, thereby impairing my client's vested rights in violation of the United States and the California Contracts Clause. The disputed
Could I just
items
begin, Mr. Mastagni, with the last question? Is the Contracts Clause limited to situations where the legislative body is, in a sense, kind of self-dealing in a way because it's reducing its own liabilities of that governmental entity?
Absolutely not, Your Honor. This Court has already answered that question in the Sonoma decision, which is on all fours with a lot of the issues presented here. In that case, the state legislature passed a statute impairing local government COLAs in their labor contracts, and it did it predicated on an expectation of decreases in revenues similar to the justifications PEPRA is based on in 2008 and the arguments alluded to with the stay-at-home orders. And there, the court found that those anticipated financial losses are never sufficient justification to impair financial terms. Importantly, they were local contracts that were being impaired. Another, since I'm on the case of Sonoma, very important aspect that has applicability here is that this court instructed that a contract can't be looked at in fragments. It has to be construed as a whole. And there they said that the anticipated wage increases in year 2 colored the wage demands in year 1 so that the employees, by performing work under the first year of the contract, had already provided valuable considerations for the expected increases in year 2. And in that case, this court applied heightened scrutiny because and found a violation of both the state and federal contracts clause. One last point on that issue is, apart and aside from that holding, here the state did have important financial interests at play. The PEPRA legislation was really AB 340 and 197, and 197, even the appellate court recognized, was just minor clarifications. And it was a package of statewide pension changes that were intended to reset pension compensation statewide at both the state and the local level. And the state had important financial interests for 2 reasons. One is that reset involved state employees, obviously, and it did it in 2 ways. It reset pension expectations for employees who hadn't been hired yet, and then it raised the impairment issues that are before the court today with respect to legacy employees. But the state also had a secondary self-interest in this because there's a statewide market, particularly for law enforcement and public safety services. And if the state were to reduce its pensions, it would be out of market with the state and local governments at a competitive disadvantage. So it did have
Councilor,
a financial
we can go back to
interest.
this in a moment, but if I could, let me ask a related question to the one Justice Liu raised. In the last few minutes, we've spent quite a bit of internet bandwidth trying to define what prospective means. So what does prospective mean to you in this context?
Thank you for that question. And I agree with the issues raised by Justice Liu. That was part of my prepared remarks. The pension formula is a function of age at entry of service, years of service, the definition as determined by the delegated authority of the retirement board as to what items of compensation are includable, and the multiplier. That equation or pension formula is applied to all years of service. So it's simply not true that it's prospective only, because in this case with my clients, the Alameda deputies, they entered into a settlement agreement that was court approved in 1999, settling their Ventura claims. And there was an agreement as to what items of compensation would be included in their pension calculations. Everybody operated under the assumption that there was finality of judgment and that that settlement agreement created a vested right, apart and aside from the vested right and expectation created by the board's determinations. And they made contributions based upon the actuarial assumptions that those items of compensation would be included. Then when PEPRA comes into play in 2013, all of the sudden those expectations are reset and the pension formula is reduced by over 15%. That formula is applied to all years of service at the end of their employment, including the years of service that they had already performed prior to the enactment of PEPRA. To put it in simple terms, my clients were offered a deal by the county. They said, if you accept a lower amount of salary than you could maybe make if you were working in the private sector and agreed to provide us 30 years of service as a deputy sheriff or a first responder, we will provide you significant amounts of deferred compensation. That promise of deferred compensation is a very important aspect of the employment agreement. Because if you think about law enforcement today, you're subject to significant public scrutiny. There's wear and tear on your body and your mind, and there's only a limited amount of time that you're able to successfully perform those kinds of services. And so those employees need to have a substantial pension so that they can survive. And the employer needs to be attractive because there's a shortage of law enforcement supply within the state. So they made these offers. And
okay,
Justice Kruger,
counsel, let me stop you there if I might. That's very clarifying and helpful in terms of setting the kind of background understanding of what perspective means to you. I'd like to take you downstream then in the analysis, assuming here that the PEPRA did change the landscape of the employee's understanding, not as a matter of express contract right, but as a constitutional matter, meaning for purposes of the contracts clause. I'd like you to say a little bit about what you understand the analysis then to be. What is the test for whether or not the legislature can change this kind of background understanding?
Certainly, Your Honor. The contracts clause was a protection that was put into place at the end of the Revolutionary War to protect stability of contracts and so that legislatures could not reset expectations after the fact. And this court's jurisprudence, as well as the Ninth Circuit, has held that financial impairments for cost savings are never necessary or never reasonable because the government can always spend money on other items. That doesn't mean that the pension is inflexible and can't be modified. But as this court has said repeatedly, those modifications have to be reasonable and they have to be consistent with the theory of the pension. The modifications have to at least generally relate to the detriments that are being imposed. And in circumstances as presented here, where there is a pure detriment, essentially for cost savings, no decision has ever upheld such impairments, and the Ninth Circuit hasn't either. The claim that this 15+% reduction in the pension formula is not substantial, it just can't withstand scrutiny. The Ninth Circuit has even said that a slight pay delay in receiving the full amount of monies owed is a substantial impairment to working class people and violates the contracts clause. This court has said it repeatedly, most recently in the case of Legislature versus You, where the court looked to the change, which was in some ways worse and in some ways lesser than the change here, because in You, the impairment was only going for future accruals of pension credit, whereas this change reduces.
Mr. Mastagni, may I ask you, just in terms of your analysis of the Allen rule, is your objection made being that there are no comparable advantages being imposed to set off the disadvantage as you describe it, or is your argument that these modifications bear no reasonable relationship to a theory of a pension system or its efficient operation?
Your Honor, I believe both of those criticisms are correct, and both of them are sufficient for holding these exclusions enacted by PEPRA as unconstitutional. There is absolutely no offsetting advantage that is being implemented. And here, as Justice Kruger noted in her concurrence in the CAL FIRE case, when an employee is agreeing to defer a substantial amount of the compensation that they're owed, there's an expectation that that deferred compensation won't be modified and impaired. And Justice Kruger, you also indicated that no reasonable employer would expect that an employee would accept employment under such terms. And what happened here is my clients were promised that they would have deferred compensation that would be calculated based upon the core components of the pension formula set forth in the SERL at the time that they accepted employment. We understand that terms and conditions of employment are subject to change and that they have no guarantee that they will receive any particular pay that may or may not be includable. For instance, you don't have a guarantee that you'll be assigned a detective and receive detective pay. But if you are assigned a detective and receive detective pay, there is a vested expectation that those payments will be included in your pension calculation.
So,
and
Mr.
that's what
my question then is essentially, and I think I get it, is that there are these disadvantages which you have ably described to us that affect law enforcement under these contracts, under these settlement agreements or the previous understanding of SERL contain significant disadvantage without any compensating advantage. To your analysis, how much of that aspect of the rule relies on should or relies on must provide advantages?
Your Honor, I think that the phraseology has been a distinction without a difference in this court's jurisprudence and its progeny. The terms are used essentially interchangeably, but the fact of the matter is this court has always required some offsetting new advantage in order to uphold a modification of the pension. In the cases, Packer, for instance, the court said that that doesn't have to be precise, but there has to be something. In that case, survivor benefit was watered down so that the employee had to elect it and take a lesser pension, but they were also given additional disability benefits and death benefits, where the court found that it was a reasonable modification consistent with the theory of a pension. These modifications are based on political considerations to reduce.
That's my second question to you, Mr. Mastagni, regarding the modifications. The state has indicated that its basis for these modifications to PEPRA affecting SERL involve closing loopholes, eliminating any quote-unquote manipulation. Several times, Mr. Onishi referred to pension spiking activity we see where the final compensation during the period of calculation before retirement is greatly increased. That's been the basis of the state's reasons, as I understand it, for purposes of these modifications. Your argument is, however, that that's not true, that in fact this is politically motivated or financially motivated, and we know from our case law, at least past case law, that financial modification cannot alone be the reason for changes to a public pension system?
Yes, Your Honor. The definition of pension spiking is an inherently political term. It's not a legal term. And one person's pension spiking is another person's expectation of a promise. There's some of the advocates for PEPRA and these changes believe that public employees shouldn't have a fluctuating benefit at all, and that it should be similar to a 401k. And they would argue that anything besides that is pension spiking, or anything besides base pay is pension spiking. But the SERL gives...
Clear here, Mr. Mastagni, the court is not using the term pension spiking in any pejorative sense, but it's from the legislative history that led to the amendments in PEPRA. But please proceed.
I understand that, Your Honor. And my point is just that that's an inherently subjective political term, and what the court should look at, in my opinion, would be what the expectations and the promises to the employees were. The SERL sets forth broad parameters for what is compensation earnable, and then delegates authority to the retirement board to make the specific definitions and look at the specific pay codes. These were key inducements to my clients. They were advertised by the county. They were advertised by ACERA. They were given detailed instructions that these items of compensation would be included in order to induce them to select working for the Alameda Sheriff's Department as opposed to another employer. And the characterization of them as spiking? Well, for instance, with respect to the terminal pay, which is really, in the case of Alameda, it's leave accrued during the final compensation period, and it's just a minor timing issue that's relatively arbitrary that it's paid at retirement as opposed to before that this claim of pension spiking is made. But if you made slight modifications in the labor contract regarding the timing, then those exact same payments would be perfectly legal, even under the state's interpretation of PEPRA. And so what I would submit is that if the state has issue with the agreement that was made, then it should change it for new employees, which it did with PEPRA. And if there's concerns about pension funding that the employer has, because another problem with the state's one-size-fits-all prescription is that it's really the employing agency that has the pension funding obligation. And so you really need to be looking at each county as opposed to saying there's a statewide underfunding problem. But there's several ways that the county can deal with these issues if they share the state's concerns. They can negotiate in labor contracts additional employee contributions towards the pension. They can negotiate changes in the terms and conditions of employment that modify the compensation items that are included in the promised definition. What I would submit...
I have a question for you along the lines of something Mr. Onishi had said earlier. And his position is that these are merely PEPRA amendments, B1 through 4, telling us what compensation earnable is not, are merely clarifications of what had always been prohibited by Searle, and that basically reasonable pensions and reasonable expectations of pensions never included the items that the PEPRA amendments now prohibit, or clearly prohibit. And his position is that isn't always been the law, and Ventura really didn't change anything about that. But I understand your position, at least implicitly, based on the people who have been receiving these benefits, that that's absolutely 100% wrong. That in fact, these have been allowed, and these kinds of payments have historically been expected and relied upon. So do you base that on a reading of Searle, or on a reading of Searle and Ventura, or just on a reading of Ventura, period?
Thank you, Your Honor. I based that opinion on the reading of Searle in light of this court's holding in Ventura and other pension cases. And I think there's no doubt with respect to the second part of your question, expectations. The expectations were clearly laid out. There was a settlement agreement that clearly articulated that these leave pays would be included, and it was advertised to my clients to induce them to accept employment. In terms of whether it was always prohibited by the law and the law was always clear, I believe it's anomalous for the state to take that position and then at the same time say PEPRA was necessary to clarify the law, where we had to identify all of these specific exclusions and put them in there. And the truth of the matter is that the definition of compensation earnable in the statute at the time that my clients accepted employment created broad parameters, and it delegated the responsibility to the retirement boards, much like the PERL delegates responsibility to the PERS board to make determinations as to each specific item of compensation and as to whether or not those are includable items of compensation. The Ventura decision gave a lot of guidance and colors those determinations, but it also left a lot of open questions for the boards to determine within their discretion. And there's an additional issue I do want to address without running into my colleague's time, which is that even if the court disagrees with me, and which I believe would essentially require finding that Ventura was wrongly decided, because Ventura specifically, as Justice Liu indicated, found broad categories of compensation includable, including specifically on-call pay, which PEPRA specifically excludes. But we also have here an express contract via the Ventura settlement agreement. And this isn't just a contract that was between a union and a county to try to circumvent the law. This was an unclear legal issue left open by Ventura. It was a class action lawsuit. It was supervised by a court. It had judicial scrutiny, and a settlement agreement was approved. And that settlement agreement essentially stayed intact until the Court of Appeal decision in 2018. So it had been intact for 19 years, and it set the parties' expectations as to what would be included and what wouldn't be included. And even if everything that the state argues is correct, which I obviously do not concede, and that the SERL never permitted the inclusion of these pays, under principles of finality of judgment, I believe that there's a vested right to the continued inclusion of those pays because, as the Third District Court of Appeal said in the Fireman's Fund case, there has to be an end to litigation. There has to be a finality of judgment. In the Chisholm case, where the parties' positions were essentially reversed and pensioners wanted to reopen a Ventura settlement to seek additional benefits, the court there appropriately said, no, you have a settlement agreement, it's enforceable. And so here you have a court-approved settlement agreement creating a vested right, and it should be entitled to the protections of finality of judgment so that the boards can settle matters and so that the pensioners understand what their rights are and the boards understand what their obligations are.
And I just want to make sure I understand the outer parameters of your argument with respect to Allen. And I guess what I hear you to be saying to reduce it is, let's imagine a pension system, a massive economic downturn, a pension system on the brink, a county's pension is going to become insolvent. I hear you to be saying that even given that doomsday scenario, if there's not a commensurate advantage, the system simply cannot make any cost savings changes with respect to existing employees, even if the pension system is on the brink. That is, I hear you to be saying better to let it go insolvent, better to let the county go bankrupt than make changes to existing employees. Does the argument go that far?
I don't believe it goes that far. And I would argue that the proper focal point is not the system, but it's the county. As the Stockton bankruptcy clearly indicated, the funding obligations are the county's. The system invests the money and processes the pension payments. And so you really would have to look at the financial condition of the county. And were the county unable to make its obligations, then bankruptcy is the forum where contracts are impaired and all creditors are treated equally. But if the system is underfunded, there's a variety of different ways that can be corrected short of bankruptcy. I mean, the simplest is to just simply require that the county provide additional pension contributions. And there is a release valve without filing bankruptcy, and that is through negotiations and changes in the terms and conditions of employment. The PERL and the SERL have always allowed variations, at least for legacy employees, on the amount of employee contributions. And the fastest way to ease those pressures would be to negotiate additional employee contributions or to have the system adjust the actuarial contributions from the employer and the employee so that it gets adequately funded. I mean, another aspect, Justice, is that the funding level of the system is not...
Mr. Mastagni, after you finish this thought, your time has expired.
Thank you, Your Honor. Is that the funding level of the system is inherently subject to change because we saw when the actuarial assumptions were modified that had significant impacts on the funding levels. But with that, I'll yield my time to Mr. Talbot.